name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is Lien and Bond Claims Masterclass, everything they don't tell you but should. So without further ado, I'd like to introduce the fabulous and wonderful Jessica Murphy.
Oh, thank you for the introduction. So happy to present on this. I'm a construction litigator and have been doing that for the past 20 years. Just came off on Monday from a 4-day jury trial on a construction issue. So I essentially live, breathe, and sleep mechanics, liens, and bonds, and happy to give the intro and masterclass here on that. So without further ado, I will move us right along here. Let's see. All right. Welcome to the webinar. If you do have questions, you can use the chat box on the right. We'll answer the questions at the end, and please anonymize them and don't use company names or client names on that. So today we're going to talk about your contract. Here's the one change that you do want to make sure that you're making. We'll talk about securing your lien rights and bond rights, rules and exceptions on liens and bonds that may be applicable to you, lien law traps to avoid because liens are very powerful and it's a great way to get you paid. And lastly, a good tip for the right way to exchange a release for payment so that you're not leaving yourself exposed at the end when you think you've got it done. Last up, we'll talk about SunRay resources and where you guys can go to file your liens with SunRay. So this is in connection with just Massachusetts mechanics liens here. The most important thing to know about your contract is that an executed contract is a necessity. You must have it signed or another substitute for a signature that is valid in Massachusetts. And what that means is that you can have a contract that you've sent to somebody else and they've responded in email, sounds good, let's move ahead. That is sufficient in Massachusetts without having a wet ink signature on a contract. Another type of way to execute that you're not signing a contract could also be if someone types their name in the signature line. There are proof issues when it comes to that to make sure that the person who is supposed to be executing it is the one who does. But there are, again, those alternative ways that you can show that there is acceptance and a quote-unquote signed or executed contract even without a wet ink signature. The preference, of course, is always to have a signature, and having it scanned and sent back to you is perfectly permissible. DocuSign or any other electronic signatures are also a great way to do it, and those give you some added verification of who it is. Your contract should also make sure to state the contract price. If it's time and materials, it makes it a little bit harder to establish an amount of the lien. So it would be great if you did have the contract price in your contract. A lot of times for larger contracts, they'll even have a term sheet on page 1 that highlights the material terms. Great place to put that in. If you are going to amend your contract documents, please do so in writing, or use change orders where applicable, especially for the amount changes and not for lien purposes, but for general best practices in construction. Always do a change order when you're having an extension of time as well, even if there's no cost associated with it. This is the one change I would suggest you make to your contract. Identify the other parties on the project, clearly identify the project address and the property owner. Those are key things that you need to know in order to assert a mechanics lien. Oftentimes I see a project address described as, you know, the Dunkin' Donuts on Main Street or the mall in a particular area. Those are really difficult addresses that are not going to help you with a mechanics lien. They may get your guys to the job or your women to the job. The materials may still make it there because people know where to go. But I would strongly suggest that in your contracts, you have the project address clearly spelled out in terms of a street address and a zip code. It's also very helpful to identify who the property owner is. and have that as part of your contract or part of your purchase order. Those pieces of information that you can get in advance of starting work are going to be critical, because that's when the project is going well. That's when everyone's eager to get started. Check and make sure that you have that information, and also identify the other parties on the project. Are there intermediary subcontractors? Are there contractors above yours? Are you supplying to a subcontractor who has a GC on the job? Identifying who else is on the job is important for notice purposes, and also to figure out where you sit in the mechanics lien process. So when you secure your lien rights in Massachusetts, the law says you have to strictly comply with the statute. You cannot be filing things at 91 days if the deadline is 90 days. So making sure that you're stating accurate information in your mechanics lien, like the date of the contract or the amount of the work. If those things are fundamentally incorrect, the law and the court will void your mechanics lien. You can initiate a mechanics lien as soon as the contract is executed. I do understand that a lot of people don't do that, and they wait towards the end to see if they've gotten paid. My fundamental recommendation is that everybody establishes a number that contracts over X dollars get a notice of contract as soon as it's executed. And those would be your larger dollar contracts. Those would be contracts that maybe are new clients of yours. But a mechanics lien is such a powerful way to get you paid. In order to get those protections, you must get that first recording. That notice of contract needs to be on record. And if you are not the general contractor, it needs to have notice delivered to the owner in order for that to be effective and start giving you rights. If people are paying in advance of that, it will not secure perhaps the amount of money you thought it would. So I strongly recommend you move as soon as you can. But if you're going to wait and see, your deadline is 90 days from the last date of work for anyone performing under the same general contractor. There is an exception to that there are opportunities for a notice of substantial completion or notice of termination to be recorded with the Registry of Deeds on a project. In my 20 years of practice, I haven't seen that. However, there are a little bit different deadlines for that. It's 60 days from a notice of substantial completion to record that first notice of contract, or 90 days of a notice of termination. So you should be checking the registry. You should be aware of what's going on. And again, keeping up on things. Know your last date of work, although you are entitled to use the last date of work of any subcontractor or supplier that operates under the same general contractor. Subcontractors must give notice to the owner of their lien. So it first gets recorded, and then notice goes to the owner. After filing and recording, your notice of contract, you record a statement of account within 120 days of the last date of work. And the last part is to file suit within 90 days of the statement of account recording. That's a fixed deadline for filing suit. The deadlines to record the notice of contract and statement of account both run from the last date of performance. You can file all these things together if you'd like. I like spacing it out so that you have the best opportunity to try to get paid in the interim without incurring more costs than you might otherwise if you did all three at the same time. So bond rights. Again, your Massachusetts law also requires you strictly comply with the Public Construction Bond Statute, what we refer to as 149, Section 29. If you do not have a general if you do not have a contract directly with the bondholder, which is going to be the general contractor, you must provide written notice of the claim within 65 days of your last date of work. So what that means is that if you are a subcontractor, you do not have to give that notice. If you are a sub to a sub, if you are a supplier to a sub, and you are on a public construction project where there is a bond, you must give written notice of the claim to the general contractor within 65 days of your last date of work. That is specific to your company. And again, that applies, the notice requirement for a bond applies only to subs as well as suppliers to subs. Everybody else, All you need to do is file suit within 1 year of the date you last worked on the project. You're going to be suing on the bond. In my experience, everybody should be giving notice because that's the best way to get you paid. And a lot of times the bonding company is going to be reviewing these and they're going to pay out short of having to file a claim on the bond itself. So here's the key lien and bond exceptions and rules that you need to know in Massachusetts. First, a mechanic's lien in Massachusetts is only for work on private property. If there are quasi-public entities, if there is public land, you cannot put a mechanic's lien on that. I did once have a client ask me to put a mechanic's lien on the town hall, and he was willing to auction it off, but unfortunately not permissible in Massachusetts. One other exception, which does trip up a number of people, is that the condominiums cannot be liened. Work inside an individual unit owner's space can be liened, and then at the end of a mechanic's lien, you would end up selling off the actual right to the inside of the condo, the unit itself, but you cannot lien and you cannot force a sale of the condominium common areas. So if there is a development, that includes the roads, that includes the laundry room, that includes the building as a whole. This is a big one for MEP contractors. So they're often saying, I'm doing the sprinkler systems everywhere. There is no mechanic's lien rights for that. So you must perform the work on the property to be liened. So be careful about providing materials that are being put to a warehouse, even if you know that they're being used for a particular job. You can only lien for things that you can prove were used on that project or delivered there. With respect to bonds, one of the exceptions you need to be careful of is pay attention to the type of bond you're getting. You want to get a copy of the bond, again, at the start of the project, right when you're gathering all the best information. Everybody is on their best behavior and wants to cooperate. Ask for a copy of the bond if you are working on a public project. You want to check to see if there is a payment versus a performance bond. A performance bond benefits the owner. A payment bond is going to benefit the contractors and the suppliers. And make sure that the work is covered by your work is covered by the bond. I have seen people get involved in projects and it turns out that this was additional work added on later. It was not included in the scope. It was a separate property, or they were shown a bond that was not valid because it was on an entirely different project. So some people don't always play by the rules. Make sure that you take a look at the bond in advance, that it's a payment bond, and that it would cover your work. Here's the lien law traps to avoid. Keep proof of delivery or performance at the project. You want to make sure that if you're delivering items, again, do you have your delivery slips? That's going to give you proof positive that you have performed the work or delivered the materials to the project. If your delivery slips are supposed to be signed, get them signed. That is a great way to make sure that you're going to get paid. Please document change orders or increases in the project cost. While Massachusetts allows you to amend a contract with a little bit less formality than entering a contract, and you don't necessarily need all of your change orders or increases in price to be documented, the best way to do that and make sure you're going to get paid and not have challenges to your lien are to get those things documented and in writing. Know the parties and their roles in the project. With your mechanic's lien, the process I described in Massachusetts is as a subcontractor. If you're a general contractor, you sit in a little bit different position. You may think that you're a general contractor, but you may actually have a contract with a tenant who is different from the landowner. And those can impact whether you have to give notices and who you have to give notices to. So know the parties, know their roles in the project, know who owns the property and exactly where you're performing. And the last one on mechanics liens, because strict compliance is so key, is don't wait. If you are going to wait until the very end to make sure that you haven't gotten paid before you pull the trigger, know that you have 90 days from the last date that anybody performs work on the project in which to record that mechanics lien. it does take time to get the materials over, to make sure you have the right deed address, make sure you know who the parties are, that you have a copy of the contract. So don't wait. You really should be looking at no more than 60 days after you haven't been paid to figure out how much more time do I have, when am I going to get this information over, what is my trigger for starting to initiate a mechanics lien. The last thing I just wanted to talk about was the right way to exchange a release for a check. This seems pretty basic, but one thing you don't want to do is inadvertently give up your mechanics lien rights before the time has come for full payment and that's been made. A lot of times the initiation of a mechanics lien by recording that notice of contract will inevitably get somebody paying attention, or the notice to the owner will get somebody paying attention. And so in between the deadline, that 90-day deadline for recording your notice of contract and the 120-day deadline for recording your statement of account, you may get a call. When somebody offers to make payment, today we are only accepting for our clients wire. Even certified checks can be forged, and those are on the increase. There is wire fraud going around as well, but wire is the only way that you have immediately available funds. I've had clients who have been tempted to take a company check on the eve of the mechanics lien deadline, and unfortunately, checks can take up to 14 days to clear the bank. There is no firm notice that a check is cleared. It just simply has to wait out that time period and not be rejected. So again, if you're getting close to your mechanics lien deadlines, make sure that if you're taking a check, you have time to have that 14 days, it's got 10 business days. So 14 days to clear the bank, and give yourself space on top of that, or make sure that you're getting the payment by wire. The same thing for the bond claims as well. You have that 1 year to file suit. Do not let that expire because you have a check in hand that you haven't cashed, or a certified check. If those turn out to be fraudulent, there are no ways to go back, unfortunately. Another thing that we've seen, there's been a rise on this in probably the last 5 or 6 years, and that when you do, even if you haven't done lien waivers along the way, certainly if you record a mechanics lien, when you get paid your final payment and they clear the lien, they will typically be asking you to sign a lien waiver. A final lien waiver is typically the end of the job, and it's okay to release more rights at the end of the project if you're done and satisfied that you're aware of what any potential claims are. But you always want to make sure that you take a look at it. Releasing a lien does not require you release all claims as to the project. So a lot of times, general contractors and owners will work on trying to get a global release of all claims that you have on the project. That may not be appropriate. So always take a look at that language. A lien waiver is really just a waiver of the lien, and that's the minimum necessary in order to get payment. So take a look at the language and make sure you're not giving away more rights than you anticipate. Lastly, the best way to make sure that you are protected is if you are somebody who has subcontractors or suppliers that you need to pay from the funds you are getting, make sure that you know how much they need to be paid and that you have conveyed the amount that you are due accurately. With that, I've just given you basically everything they should tell you, but they don't, about mechanics liens and claims in Massachusetts, bond claims in Massachusetts. Hopefully you've learned something new here. I'm happy to take any questions if there are any right now.
Well, first of all, Jessica, as always, you are wonderful. Thank you so much for that. We do have a couple of questions that came through. The first one, it says, what is the deadline to foreclose after you lien the property?
So the foreclosure process after liening the property is interesting in Massachusetts. You must do your notice of contract, your statement of account, your recording, your filing of the complaint. The complaint then gets recorded with the Registry of Deeds as well. At that point, you have an active litigation. You must win your litigation. And as part of the judgment, In a case in which you have a mechanics lien claim, the judgment will order the property to be sold. So you will then take that order and present that to a sheriff to commence a sheriff sale on the property. So that process is not particularly expedited. The only times I've seen that happen quickly has been when there's a default, which means that you file your complaint, you give notice to the other side, but they do not participate in the litigation. And so you would get an expedited judgment on default, and you get that order to sell the property that much quicker. In 20 years of doing mechanics liens, I've only had 2 cases that went to a judgment because the lien is so powerful that the property will get sold. Nobody's looking for that. Typically, the value is not, the value of the property is more than the lien amount. So in those most cases, those are going to be resolved well in advance of a foreclosure.
All right, perfect. Thank you. Another question that came through, it says, what happens if the property is sold prior to the lien being recorded and then the lien is recorded? Do I have to then release that lien, and what are my next steps?
Great question. Yes, if the property is sold before you record your lien is ineffective. Whether or not you have to release it, that does depend on if somebody asks for it. Technically, it's invalid because they no longer own it. That's why there's a lot of urgency to making sure that you are doing these things timely and getting at least your notice of contract recorded early. If it is sold after you record your notice of contract, the new owner takes subject to your lien. If you record after the property is sold, the only exception to it being invalid would be if there was some type of collusion between the parties. They may try for a quick sale after the construction to avoid liens. If there is collusion there, I have seen one case where the judge had ordered the property to be restored to the prior name and allowed the liens to continue. It's a very rare circumstance. So you are beating against the clock, and that's why we recommend the notice of contract goes on as early as possible.
Perfect. Thank you so much for that clarification. And then another question that came through, it says, can delay damages, interest, lost profit, attorney's fees, and or filing fees be included in that amount, in the lien amount, or collected afterwards?
Yeah, that's a great question. A mechanics lien is, the short answer to that is no. Those are not recoverable fees on a mechanics lien. The mechanics lien is specifically against the owner of the property, or if there's a tenant who's doing the construction, against the tenant's interest. It is typically somebody that you do not have any other relationship with. So, for example, if you're a supplier and you are supplying materials to a project, you may be supplying it to a sub or a general, but you don't have any relationship with the owner. So if you are owed money on that, you get the value of what you provided to the job. And that's typically determined by the invoiced costs, for example. If you have interest on that, the idea about interest is only something, or attorney's fees in Massachusetts have to be stated in the contract. The contract under which you have maybe an 18% interest, which is higher than statutory, or if you have the right to recover attorney's fees, those are in your contract with your subcontractor, general contractor, or somebody else on the job, not the owner. So in those cases, the only amounts you can get from the owner are going to be the value of your lien. And technically, you're not getting cash from the owner, you're selling the property. And so there will be post-judgment interest applied. But what you're really looking at there, if you're looking for your delay damages, if you're looking for your interest, if you're looking for, a higher than statutory rate, or if you're looking for attorney's fees, the way we handle that is that when we have to file the complaint in order to enforce the mechanics lien, we are also filing suit directly against the party you contracted with, and that's the party who would have signed the contract and is responsible for those fees. So unfortunately, the mechanics lien gives you a lot of powerful rights against the owner, but it is only essentially for the cost of what you provided.
All right, perfect. Thank you so much for clarifying that. That does appear that that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out. We'll be sure to answer any questions for you. Can you go to the next slide for us, please? All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please make sure that you are looking at the actual state in which your project is taking place in. Every state is unique. It has its own unique deadlines and documents, document names, all those types of things. So please check it out so that way you will be in the know and knowledgeable as to what you have to do in order to secure your rights on that project. All right,
and Jesse, that's a, yes. I was gonna say, Jesse, that's a really important thing too. It is where the project is located, not where any of the parties are located. So yep, check the right state for where the project location is.
Exactly. Thank you. All right. And then on this slide, if you guys don't mind, give us a quick moment of your time to give us a review. We really do appreciate it. Any feedback that you're able to provide, it always helps us better ourselves and make sure that we're getting content out that you need. It also helps other contractors and suppliers like yourselves get the information. So we really do appreciate any feedback. All right. And then the next slide, if you don't mind. And with that, that is all we have for you guys today. Thank you so much to everybody who was able to attend. We hope to see you guys at our next webinar. Jessica, I really can't thank you enough. You really are wonderful. All right, I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.